Hello everyone, welcome to the first lecture of the Indian Contract Act 1872. I think this is one of the first acts which any law student studies. It's the most relatable act, I think. You can completely relate the act to your daily routine life, and you can pick up so many examples from your life and connect the act with it. So it's a very practical, it's a very relatable act, and this is one of the most interesting acts. It's my favorite too. So let us begin our journey together, and we will discuss the Indian Contract Act, the basics of the Contract Act. And in today's session, I will teach you the definitions as well as the elements of a valid contract. But we will also understand what is a contract, what is an agreement, how both are different, and then we will discuss the essential elements. All right, so let's get started. But before I discuss any particular provision, let us understand the type of questions that are asked from this chapter and what are the important topics that you should pay attention. So basically, a case-based question can be asked. Now, what is a case-based question? A situation will be given to you, something like this. Okay, so a situation will be given to you. This is for partnership, actually. So this is the first chapter, that is the Contract Act. I have already made the discussion video. So something like this, a situation will be given to you, and you will be asked to analyze, apply the provisions, and find out the solution. Okay? So this kind of case-based question can be asked, or a pure theory question can be asked, wherein they will ask you to explain all the essential elements of a valid contract. So if you are appearing for an exam which has a combination of both, so yes, both type of questions can be asked. If you are preparing for an exam in which you will be asked only theory question, so then I don't think there is any reason for dividing the chapter into either case-based questions or theory question. So if you are very clear that only theory questions will be asked, then it can be asked on any part. And if you are preparing for an exam which has only MCQs, then you need to study everything, because MCQ can be asked from any of these provisions. Now, questions are generally asked. Okay, you take any examination. Questions are generally asked on the concept of enforceability. What is it? We will be understanding very shortly, but questions are generally asked on enforceability. And in that, yes, business or commercial transactions, social or domestic. So that is one classification on which questions are generally asked, basically on social or domestic agreements. Then questions are generally asked on certainty of terms. Questions are asked on legal formalities. These are various elements. Okay, so question may be framed around these concepts. So enforceability, certainty of terms, possibility of performance, so questions are generally asked on these topics. Okay, now before we discuss the Indian Contract Act 1872, what is your understanding of law? Okay, because see, it's a very basic term. But unless and until you don't understand what is law, how will you be able to understand what is an act, and what are the provisions of this Indian Contract Act, what are section numbers? How will you understand unless and until you don't know what is law? I don't want any legal definition. I just want your interpretation of law. Law are rules and regulations. Yes, if you say this, it means your answer is correct. Rules everywhere. Rules at home. Come before 10. Sorry, that was my time. At least come before 12 o'clock. Rule of college, 75% attendance is compulsory. We don't follow that rule. That's a separate story. But there is a rule. The rule of my class, you will concentrate and watch the lectures. You will go through all the writing practice exercises. You will solve the questions on your own. These are the rules of my class. Rules of society. Can you walk with a gun? And if someone pushes you, you shoot him. Can you behave in this manner in the society? No, no, no. There are rules in the society. You need to follow those rules. So there are rules at home, there are rules in college, there are rules in class, there are rules in society. Similarly, there are rules in business also. If you have purchased the goods, you will have to pay for the goods. If you have taken services, you will have to pay for the services. So there are rules everywhere. When these rules they come together, it forms an act. And when many acts come together, it forms law. So when all these rules they come together, it first forms an act. And when many acts come together, it forms law. So the Contract Act comes under business laws. Why? Because this act basically applies to business transactions. So business law covers the Indian Contract Act 1872. So this is a basic understanding of law. Now, to give you some information about the act so that it helps us to understand the acts that we are going to study very soon. The act is first divided into chapters. Like say for example your textbook. It is first divided into chapters. These chapters are divided into various sections. So like see this. This is one chapter. It is divided into different sections. Like today we are going to study the definitions. Then we will be studying the essential elements of a valid contract. So your act is first divided into chapters. So we have the Indian Contract Act that we are studying. In the Indian Contract Act, my first chapter is discussing nature of the contract. My second chapter discusses consideration. So like this, the act is first divided into chapters. The chapters are then divided into small sections. Sections are divided into subsections, which are then divided into clauses and subclause. Let's not go beyond that. So section will be written something like this. So you have section 10. 1 means it is a subsection. A means it is clause. Ma'am, how are we going to understand all this? See, when you get a question, so in the margin you write question 10. Okay. Then you write the first sub question, that is 1. In that you start explaining. So you write A. So in this manner, the act is also framed. So this is the question number. Then in that I have the first sub question. In that if I want to explain something, I write A. In that if I want to explain something, I write a small 1. So in the same manner, if you want to explain the main section, it will be written like this. If something is related to that main section itself, then that is a subsection. It's a part of the main section. In that subsection, if I want to explain something, then that becomes a clause. Okay. Then when I shift to the new point, then again I add a subsection. It means it is something else now, but related to the main section. So that is how you will read. It's a very basic understanding. Actually, it is quite deeper, but I don't think that is required at our stage. So that is something about law. So law is nothing but a set of rules. When all these rules come together, it first forms an act. When many acts come together, it forms law. The Indian Contract Act came into force on 1st September 1872. So the Indian Contract Act was enforced. It commenced on 1st September 1872. But ma'am, we are very sure that contracts may have been entered even before 1st September. And what about those contracts? See, the Indian Contract Act was not applicable before contracts entered before 1st September 1872. The English Contract Act applies to the contracts entered before 1st September 1872. Okay. So for the contracts entered after 1st September, the Indian Contract Act applies. But what about contracts before 1st September? Then the English Contract Act applies, because that time we had Britishers in our country. English Contract Act applies. Even today, if there is any confusion, if there is ambiguity, there is confusion, there is no clarity in the Indian Contract Act, even today, we refer the English contract, right? Because their judiciary is our and their judiciary is same. Anyways, they were ruling us, so they only created the judiciary which we are still following. So because it is the same, we can still refer the English Contract Act. The Indian Contract Act applies to the whole of India. It also applies to Jammu and Kashmir. Earlier, there were many acts which were not applicable to Jammu and Kashmir. Article 370, but now after the removal of Article 370, the acts apply to whole of India. These are few important definitions. I have given the definitions together in the start so that it is easy for you to learn, understand, and revise one day before the exam. How to remember the section numbers? How to remember the definitions? That is one question which every student has. Ma'am, how to remember these numbers? Is it important for exam? I think yes, it will add value to your paper. It will make your paper better than your friends. So you will definitely get more marks. Now, this is section 2. Now, definitions are generally given in section 2. So, definitions are mostly covered in section 2. Okay. Why are definitions important, etc.? Although that is not related to our discussion, but it will help you later when you study some advanced course, etc. Now, instead of explaining this word again and again whenever it is used in the act, instead of doing that, why don't we define it at one place, and then whenever it is used in the act, it will have the same meaning? That is why you will find that the definitions are given in the initial sections like section 2 or maximum section 3. Whenever this word is used in the act later on, it will have the same meaning. So there is a uniformity which is brought about. So what is offer? And I don't think we will have to go through the meaning. Whenever the definition comes, I will explain it to you. At this stage, what we need to know is how to remember the section numbers. Now, please pay attention, students. This is section 2. That much we are clear. I just explained to you that after section, we have subsection. But here, directly, we have clause. Okay. Now, this happens only in case of, mostly, not only, I cannot say that, because many a times after section, we directly jump to clause. Ma'am, why? Why don't you follow this sequence? After section, you should have subsection. Why are you jumping directly to clause? See, students, subsection is introduced only when it is related to the main section. But I don't want any point which is connected. I want to start with a fresh topic. Then we directly jump to clause. So after section, we will directly jump to clause. Now, every definition is separate. It is different. Is this definition dependent on the other? Is this definition dependent on the others? No. They are all explaining different terms. They are all explaining different words. Because each and every point is separate, we directly jump to clause. Subsection means it is a part of the main section. Is this related to each? Are they related to each other? No. They are all different words. They are all different terms. That is why we directly jump to clause. And sometimes small a is written, but sometimes you have also seen 1, 2, like in Companies Act, you have section 2, clause 1, clause 2. If you write A, B, C, if you are using the alphabets, there are only 26 alphabets. They are not even alphabets, they are letters. Alphabet is a set of letters. So there are only 26 letters. Yes, there are only 26 letters. So if in your act there are less than 26 definitions, then use ABC. But in Companies Act, there are more than 26 definitions, so we can't use ABC. In that case, the clause will read as 1, 2, 3. So section 2, clause 1, section 2, clause 2, because there are more than 26 definitions. So that is something about clause and subsections. How to remember these sections now? Before I discuss this, let us first understand what is offer, what is acceptance, what is an agreement, what is a contract. Only then these words will make sense, right? So let me take the liberty of diverting your attention from the definition to a very practical example, which will help us to understand the entire concept of contract. Let's say Karan Johar wants to make a movie बहुत कुछ होता है, which will be a sequel of कुछ कुछ होता है. So he approached his favorite actor, Shah Rukh Khan. He said, Shah Rukh, I want to make a movie, बहुत कुछ होता है, which will be a sequel of कुछ कुछ होता है. Will you act in my movie? Shah Rukh said, you leave the script, I will read it, and if I like it, I'll commit, I'll confirm. So Karan left the script. Shah Rukh read the script, and he said, fantastic. I will work in your movie. He called up Karan and said, I will work in your movie. Karan says, promise na? Don't say that later on I have changed my mind. He says, no, pakka promise. Then Shah Rukh asks, how much money will you pay me? He said, I will give you X amount of money. He said, okay. Karan says, what about the dates? Shah Rukh says, all the dates are yours. Anyways, I don't have much work. So like this, they made many such promises and both of them went home. In the evening, Shah Rukh was sitting in his office and he thought, what if Karan decides to cast a younger actor, Ranbir Kapoor, instead of me? What if he says I'm too old for the movie? I have given him dates and I will suffer a huge loss if he doesn't cast me in his movie. So he called up Karan and he said, Karan, we need to meet. Karan says, okay. It's a business meeting. Why are you laughing? He says, okay. Then Shah Rukh calls him to his office the next day and he says, Karan, what if you decide to cast someone younger instead of me? I have given you all my dates. I will suffer a lot of loss. He said, you're my best friend. Do you think I will ditch you? He said, no. Business and friendship are two different things. If you don't cast me in your movie, I will file a case against you. Karan says, see, that will not happen. But Shah Rukh, if you refuse to work in my movie, even I can file a case against you. Fair enough, no? From this, we have come across many concepts of contract. The first one being a promise. A proposal. Proposal means offer. A proposal, when accepted, becomes a promise. So the first element that we discussed was a promise. A proposal, when accepted, becomes a promise. Look at my hand movements. This will help you to remember the definition. A proposal, when accepted, becomes a promise. In my example, who had given the offer? Who had given the proposal? Karan. And who accepted that proposal? Shah Rukh. A proposal, when accepted, becomes a promise. Was there just one promise in my example? No, there were many promises. Will you work in my movie? Yes. Will you give me the desired dates? Yes. Will you give me X amount of money? Yes, there were many promises. When all these promises, when they come together, it forms an agreement. When all these promises, they come together, it forms an agreement. How is agreement defined? See, I have mentioned the definition over here. Every promise and every set of promises forming consideration for each other is an agreement. If there is one promise, even then it becomes an agreement. If there are many promises, even then it will form an agreement. Every promise and every set of promises forming consideration for each other. Wait, what is the meaning of consideration? Consideration means something in return. See, we are not going to work for free, okay? If I am giving you my services, I want to be paid for it. I want something in return. And Karan says, if I am paying you, I want your services in return. So both the parties must get something in return. So what is the consideration for Karan? Services given by Shah Rukh. And what is consideration for Shah Rukh? The money given by Karan. So if Karan is giving money, he wants services in return. And if Shah Rukh is giving services, He wants money in return. So both the parties must get something in return. Then that is an agreement. Ma'am, give me something very easy to remember. Agreement is nothing but offer plus acceptance plus consideration. Okay, so every promise and every set of promises forming consideration for each other is an agreement. Agreement is nothing but offer plus acceptance plus consideration. Did my example end here, or was there something else? I can file a case. If one party defaults, other party can take action. So yeah, so over here, Shahrukh was very clear. If you don't cast me in your movie, I will file a case against you. And Karan also mentioned that if you don't work in my movie, even I can file a case against you. So there was one more element, and that element is enforceability. Enforceability means intention to sue, intention to file a case. If one party defaults, other party can take action. When all these elements, they come together, it forms a contract. So contract is nothing but agreement enforceable by law. Agreement means offer, acceptance, consideration. When I add the element of enforceability means I can file a case. When I add that element, then it becomes a contract. See, in case of an agreement, there is offer, acceptance, consideration. Parties cannot file a case. But if I can file a case, then that agreement becomes a contract. Ma'am, this is very confusing for us. Can we discuss more examples? Of course, we will discuss more examples. But first, before we discuss, is this correct? Agreement is offer plus acceptance. Let's leave consideration for the time being, okay? Can I say agreement is offer plus acceptance? Yes. Can I say contract is nothing but agreement plus enforceability? And what is agreement? Offer plus acceptance. So in order to make a valid contract, I need three elements: offer, acceptance, enforceability. I need three elements: offer, acceptance, enforceability. Now, if you find these three elements, it's a contract. If one of the essential elements is missing, it's not a contract. Okay, let's understand with more examples. All my examples are going to be in arrow format. So it will be something like this. X offered to sell his flat to Y for 50 lakhs. Y agreed. Y said, okay, I will buy it for 50 lakhs. Is there offer? Yes. Did Y agree? Yes. What is it? It's an agreement. Okay. But if I want to make a contract, I need enforceability also. Now think, okay, think. X gave the flat, but Y is not paying money. Can X file a case against Y and recover the money? Logically speaking, yes. All three elements are present. It is a contract. Law is happy if it is a contract. They are not happy with just an agreement because you can't file a case now. But yes, if it is a contract, it is enforceable by law. That is what we want. One more example. X gave 5 lakh rupees to Y to kill Z, Supari. X gave 5 lakh rupees to Y to kill Z. Y says, done. Work is done. Consider it done. Was there offer? Yes. Acceptance? Yes, Y agreed to kill Z. What if X paid 5 lakh rupees to Y, but Y says, no, no, I have left all this work. I will not kill Z. Can we go to the court and say, Judge, he took 5 lakh rupees from me and now he's not killing Z. Please tell him to kill Z. Is there any enforceability? No, there's no enforceability. This is just an agreement. It's not a contract. This has no value in the eyes of law because, see, if you cannot file a case, then that thing has no value in the eyes of law. Let's take another example. I'll just repeat this here. Let's say that X and Y, they were watching a cricket match. Okay. X said India will win. Y said, no, no, India will lose. There was a bet. So they bet with each other whether India will win or not. Is betting legal? Okay, keep that answer in mind. Was there offer? X says, I think India will win. Y says, no, I don't think India will win. They are entering into a bet. Yes, there is offer. Is there acceptance? Yes. But if India wins the match, X wins the bet. Y is not paying money. Can X recover that from Y? There's no enforceability. Will this be a contract? No, it's just an agreement. And that agreement has no value in the eyes of law. See, when you cannot file a case, law says, for me, it doesn't even exist. I'm not concerned. So this is just an agreement. X sells apples to Y. Okay, he sells apples to Y and Y agrees to pay rupees 100 per kilo. Was there offer? Yes. Is there acceptance? Yes. Y has paid money in advance, but X is not giving apples. Can we file a case? Yes. Is it a contract? Yes, it is a contract because there are all three elements present. X invites Y for dinner. Y agrees. He said, yes, I will come sharp 8 o'clock. Y promised, but he fails to turn up. Was there offer? Yes. Was there acceptance? Yes. If Y fails to come, can X file a case against Y? No, they are just friends. We never intend to file a case against our friends, just friends. This is just an agreement. It's not a contract. It's not a contract. Students, from this, can I conclude that in case of business, commercial transactions, I didn't even specify, but you on your own told me, yes, ma'am, there is enforceability. But in case of social or domestic agreements, there is no enforceability. Yeah, we never intend to file case against our friend. Now, your mom, she promised to make pav bhaji for you today evening. Then when you reached home, some boring vegetable was made. Can you tell mom, you didn't fulfill your promise? Come to the police station. Can we file a case? No, that's not possible. She's our mother. We never intended to file a case. So in case of business or commercial transaction, in case of business or commercial transactions, there is a presumption. Okay, there is a presumption. We presume there is a presumption to file a case. If one party defaults, other party can take action. It is assumed that you need not even agree. You need not even tell each other. It is understood. It is presumed, it is understood that if one party defaults, other party will take action, can take action. So it is presumed, it is assumed. It is implied that if you fail, other party will take action. But in case of social or domestic agreement, or you can say domestic transactions, social is between friends, domestic is between family members. There is no presumption to sue, there is no presumption to file a. We never assume that, if I don't fulfill my promise, my friend will file a case. But let's say, for example, that husband and wife, this is a domestic agreement. Wife knows that she cannot file a case because there is no such presumption. So she is very smart. She has studied law. Husband promises to pay 25,000 rupees to wife. Wife says, wait. Law assumes that in case of promises made between husband and wife, there is no intention to create legal relation. But you are making a promise. I have studied law. I want you to give it in writing. I will also get it registered. Now, if you fail to pay, I am showing intention to file a case. I will file a case against you. So, even in case of social or domestic agreement, by putting the agreement in writing, by getting it registered, by discussing with the other person that if you fail, I will file a case, then yes, you are putting enforceability, even if it is domestic, even though it is domestic, by showing enforceability, you can treat it as a valid contract. Okay, so what I want to say is that by default, in case of social or domestic, there is no presumption to sue or file a case. But you may add intention in this manner. Even if it is not in writing or registered, you can make a written agreement wherein you have specified that if you fail, I will take action. At least mention, at least show that you intend to take legal action. Then, in spite of the fact that it is a domestic agreement, you can still enforce this in the court of law. Okay, so this is something which you need to keep in mind. I hope now you are very clear as to what is agreement, when does it become a contract, what is the difference between agreement and contract. Yes, it'll be very easy for us to understand the definition now. See, we are not reading the definition. That I will explain when it comes. What we are understanding is how to remember the section numbers. Now, in order to make a valid contract, how many elements do I require? Offer, acceptance, consideration, enforceability. Yes, I need offer. Offer is the starting point of contract. No offer, no acceptance, no contract. Because it is the starting point, it is defined under section 2 clause A. Yes, so section 2 clause A defines offer because offer is the primary requirement. It is the most important requirement. If there is offer, then only there will be acceptance. Offer is the starting point. Once the offer is given, then it must be accepted. Acceptance is defined under section 2 clause B. Section 2 clause B defines acceptance. So there is offer, there is acceptance. A proposal, when accepted, becomes a promise. Yes, it becomes a promise. The person who promises is known as the promisor, and the person to whom the promise is made is known as the promisee. So there is a promise, there is promise. So there is offer, there is acceptance. A proposal, when accepted, becomes a promise. The person making the proposal is the promisor, and the person to whom the proposal is made is a promisee. Okay, so that is the next step. So I have offer, I have acceptance, it is a promise, I need consideration, then it will become an agreement. So then the next element, the next definition is consideration. Okay, section 2 clause D defines consideration. So I have offer, I have acceptance, I have consideration, it becomes an agreement. See, such a logical flow. So offer, acceptance, a proposal when accepted becomes a promise. Persons are known as promisor and promisee. There is consideration, it becomes an agreement. Now, I made a promise, you made a promise, there were so many promises. These promises are known as reciprocal promise. Reciprocal means I gave a promise and I got a promise in return. Reciprocal promise. Okay. Now, if all the elements are present in the contract, then it is a valid contract. But if one or the other essential element is missing, then it is a void contract. Void is the opposite of valid. But here they have written agreement. Agreement means it never matures into a contract. Okay. This is not at all enforceable by law right from the beginning. Later on, we will be studying the classification of contract. There I will explain what is the difference between void contract and void agreement. But over here, just listen that this contract is unenforceable right from the beginning. This is unenforceable right from the beginning. There is a Latin phrase for it. They are talking about void ab initio. Void ab initio means void right from the beginning. I will discuss this concept. I will be discussing. This is just an introduction. Okay, but if all elements are present, then it becomes a contract. Yes, then it becomes a contract. There was a valid contract. But later on, due to certain circumstances, now it cannot be enforced. It becomes a void contract. Okay, before that, we have voidable contract. Okay. A contract which can be enforceable at the option of one party but not at the option of other. How to remember the sequence? See, it is very easy. If one or the other essential element is missing, then it's a void agreement. But if all elements are present, only then it will be a valid contract. So there were so many promises. We made promises. We got promises in return. But if one or the other essential element is missing, it will not form a contract. For a valid contract, I need all the elements to be present. All elements were present. But due to some reason, I decided that the contract cannot be enforced. It's a voidable contract. I'm not getting into the details now. We will be studying it shortly. Contract was valid when it was entered. But later on, due to certain circumstances, now that valid contract cannot be enforced. It becomes void. See, void is the opposite of valid. Yes, void is the opposite of valid. So it was a valid contract, but now there are certain circumstances because of which I cannot fulfill my promise. I cannot perform the contract. It becomes void. What is enforceability? We just discussed. Enforceability means intention to sue, intention to file a case. If one party defaults, other party can take action. In case of business or commercial transactions, we presume that there is intention to create legal relation. You need not agree upon it separately. It is assumed. But in case of social or domestic agreement, there is no such presumption. Parties do not intend to create legal relation. However, they can impose legal relations separately. An agreement is said to be enforceable by law if it creates some legal obligation. It means that if one party defaults, other party can take action. In case of business or commercial agreements, the usual presumption is that parties intend to create legal relation. But in case of social or domestic agreements, the usual presumption is that parties do not intend to create legal relation. This is extremely important for exam. Okay? You take any exam. This is very important. Now let us jump into the essential elements of a valid contract. You may find that, ma'am, you're going very slow. These are fast track lectures. We thought you will be explaining everything very quickly. This is so slow. Students, this is just introduction and warm up. There are many students who have not even understood the meaning of contract. So if you have not understood what is contract, how is it different from agreement, me teaching all this will be of no use. Okay, so your basics should be very clear. Now, what are the essential elements? Firstly, I need two parties. I can't give the offer to myself. Will you buy a car? Yes, I will buy my own car. That's not possible, no? So I need minimum. So minimum, okay, minimum. Two distinct. Distinct means different, separate. Okay, I need distinct, different, that is separate parties. Okay. I need two distinct, very separate parties. I can't give the offer to myself. Then there must be proper offer and acceptance. Wait. What is the equation of contract? Agreement plus enforceability. Can I also write? If you must have answered in this manner, that is also correct. Contract is offer plus acceptance plus enforceability. Some students say, ma'am, write consideration also. Okay, I'll write that also. Offer is the starting point of contract. No offer, no acceptance, no contract. So offer is the starting point of contract, and this offer must be properly accepted. Only then it will become a contract. No? That is the very start of the contract. Offer must be properly communicated. Similarly, acceptance must also be communicated. How will we communicate this offer? See, when the other person comes to know about the offer, only then he can accept it. How will we communicate the offer to the other person? You can do it orally. You can write a letter, write email, send fax, orally writing. You can also give your offer by action. All this we will be discussing later. By action or conduct. Like bus is running on a fixed route. It's an offer. I am going to the station. If you want, you can board the bus. We board. That is implied acceptance. So see, bus is running. No words are used. It's an implied offer. I am going to the station. If you want, you can get in. We board. That is acceptance. We are using a service. We will pay for it. Sometimes words are not used. It is understood from our action. So orally, writing, even electronically, you can send offer. It's all open. There must be intention to create legal relation. That is nothing but enforceability. That is our third element. Enforceability means intention to sue, intention to file a case. If one party defaults, other party can take action. In case of business or commercial agreements, the usual presumption is that parties intend to create legal relation. But in case of social or domestic agreement, there is no such assumption. We assume that parties do not intend to create legal relation. There is a very interesting case law, Balfour versus Balfour. Now, what are the facts of this case law? Balfour versus Balfour. Mr. Balfour and Mrs. Balfour, they were enjoying a holiday in London when suddenly Mr. Balfour, England, okay, when suddenly Mr. Balfour was called back to his place of work in Sri Lanka. So he told Mrs. Balfour, come on, pack our bags, we need to go back to Sri Lanka. Mrs. Balfour says, no, I can't travel. I have developed arthritis. Arthritis means severe knee pain, swelling. I can't travel. The jungle climate of Sri Lanka is not suitable for my condition. I can't come. So Mr. Balfour says that you stay in England only. She said, how will I stay alone? I don't have money. So he promised to pay. Okay, he promised to send £30 per month for her maintenance. After making this promise, he went to Sri Lanka. So after making this promise, he went to Sri Lanka. Promise to kar diya, but he failed to keep his promise. Mrs. Balfour got wild. She said, you have not sent me the money. She filed a case. Now you tell me, students, would she have won the case or lost the case? Correct. It's a domestic agreement. In case of domestic agreement, our presumption is that parties never showed that they had any intention to create legal relation. Agreed, he promised, but husband and wife, they make so many promises to each other. If each promise becomes a contract, then everybody will be sitting in the jail only. Husband promised to take his wife for dinner and for movie also. He said, be ready at 6 o'clock. I will come home early. We will first have dinner and then we will go out for a movie. Sorry, we will first go out for a movie and then we will have dinner. Wife is ready from 5 o'clock only. But husband came home at 11 o'clock because boss gave a lot of work in office. Can she say, come to the police station? You did not fulfill your promise. See, if small promises between friends, husband, wife, they start becoming contracts, everybody will be in the jail. So that is why law has a presumption. Arey yaar, please, you solve it on your own. Don't come to me. We have more important cases like fraud, murder, etc. We are not here to see why your husband did not take you for a movie. So even though he promised, but he did not keep his promise, you please solve it on your own. We assume that there is no intention to create legal relation in such promises. However, now let us twist the example a little. Mrs. B is very smart. Mrs. Balfour has studied law. She told her husband, wait. I have studied law. You have promised, huh? Now you write and give it to me. She took this in writing, plus she also got this registered. Now she is infusing intention. What if husband fails to pay? Now Mrs. Balfour can file a case and she will even win the case. So although there is presumption, you can add enforceability. Okay. The next element is that there must be free consent. Consent is defined under section 13 and free consent is defined under section 14. Consent means that the parties must agree upon the same thing in the same sense. The Latin phrase for that is consensus ad idem. Now, if I say, do you want to buy this pen for 10,000 rupees? You say, okay, I will buy it. We are agreeing upon the same thing in the same sense. We have consented. I say, do you want to buy this mouse? Okay, do you want to buy this mouse for 200 rupees? You say, okay, I will buy it. We are agreeing upon the same thing in the same sense. We have consented. One last example. Let's say every day I come to class in a Mercedes car. I don't, but very soon I will. Okay, I come to class in a Mercedes car. One day I came to class and I made an announcement. I want to sell my car for rupees 1 lakh. Anyone who's interested in buying, please bring the money tomorrow and the car is yours. Everybody was interested. But the student who got the money first, I gave him the key and I said the car is parked outside. He ran and he saw a Maruti 800. I have two cars, Mercedes and Maruti 800. When I said in the class, when I announced, I said, I want to sell my car. Which car? I did not specify. You thought that because I come to class in a Mercedes car, I'm referring to Mercedes, but I always had Maruti 800 in my mind. Are we agreeing upon the same thing in the same sense? No. We are not agreeing upon the same thing in the same sense. We have not consented. This will not be a valid contract. Consent must be free. Nobody has forced me to enter into the contract. I have given my consent freely. Only then it will be a valid contract. So there are two requirements. One is parties must consent. And the second is that this consent must be free consent. Nobody is stopping me from giving my consent. Consent is not free when it is caused by coercion, undue influence, fraud, misrepresentation, and mistake. Students, for the time being, I'm keeping these concepts on hold because we are anyways going to discuss these concepts in detail in Unit 3. Okay, so I'm not discussing it now. I'm going to discuss it in detail in Unit 3. So automatically you will be able to understand these concepts well. Okay, now. Parties must be capable of entering into contract. Section 11, it specifies the persons who are competent. Competent means they are capable of entering into a valid contract. So, who are capable of contracting? Major person, someone who has completed 18 years of age. Person of sound mind. Sound means he is a rational person. He can form rational judgments. He can take his own decisions. Only such persons are capable of contract. See, how can you enter into contract with minor? No, ma'am, we have seen in movies, in TV shows, all these minors are entering into contract. It is by the guardian on behalf of the minor. And again, we are going to discuss all this in detail in Unit 3. So this is just an introduction. Person should not be disqualified. Ma'am, I want to know who are disqualified. Alien enemy. foreign sovereigns, convict, insolvent. See, alien means foreigner. Alien means foreigner. And enemy means we are at war with that person. So you cannot enter into contract with a person who is citizen of a country with whom we are at war. You can't enter, they are disqualified. Foreign sovereigns includes king, queen, monarchs, rulers, diplomats. They have immunity. Imagine you are entering into contract with a king of England and you don't perform the and he doesn't perform the promise. Can you file a case against him? He's the king of England. You can't file a case against him. That is why he's not qualified from contracting. Convict, but they do enter into contracts. I will discuss in detail. Let us proceed first. Convict means a person who is in prison. Now, a person who is in prison cannot enter into contract because he's not capable of fulfilling the contracts. He comes out of prison. Then he can enter into contracts. Then it is valid. So once he's out of prison, then he can enter into contract because now he's capable of fulfilling the contract. Again, we are going to discuss all this in detail in Unit 3. This is just to introduce the concept. Insolvent, bankrupt person. What will you do by entering into contract with a bankrupt person? He doesn't have anything only. So we cannot enter into contract with an insolvent. They're disqualified. So you cannot enter into contract with minor. You cannot enter into contract with a person who's of unsound mind. He's mad. He's crazy. Someone who's disqualified. You cannot enter into contract with them. So section 11 actually points out the persons who are qualified, who are capable, who are competent to enter into contract. Okay. Let us now discuss one very interesting and very important concept of every contract, lawful consideration. Consideration is one of the most important element of a valid contract. No consideration, no contract. See, if you are not going to get anything in return, on what basis will you file a case? Like, I gave you my flat for free. Then I went to the court to file a case. Judge is asking me what you didn't get in the contract. I said, no, actually I was not going to get anything in the contract. I gave it for free. I just wanted to file a case and see how it goes. The judge will kick me out of the courtroom. No consideration, no contract. Now, what is the meaning of consideration? Consideration means something in return, and the Latin phrase for that is quid pro quo. Okay, now, do we need to remember all these Latin phrases for exam? See, if these are small phrases and you can remember, I would definitely encourage you because it shows the examiner that you have done something extra. You know, you have taken extra effort, something which the others have not done. It casts a very good impression. Both parties, this is very important, that both the parties must get something in return and that consideration must be lawful. Now, I'll explain consideration in detail so that we can use that knowledge for Unit 2 also, wherein we will discuss consideration in detail. Now, X agrees to sell 100 cans of juice to Y for rupees 10,000. If X is giving juice, what is he getting in return? 10,000 rupees. So consideration for X is 10,000. If Y is giving 10,000, what is he getting in return? Juice. So consideration for Y is juice. Both are getting something in return. It's a valid contract. And selling juice is lawful, no? This is lawful consideration. X agrees to sell 100 bags of rice to Y. And Y says, I don't have money. I will give you 100 bags of wheat. We are not concerned whether you get money, whether you get goods. You must get something in return. Partly goods, partly money, partly goods, services, money. Anything will do so long as there is something in return and that something has value. So here X gave 100 bags of rice to Y and Y gave him wheat. What is the consideration for X? Wheat. What is he getting? Wheat. And what is the consideration for Y? Rice. Both are getting something in return. There is valid consideration. It's a valid contract, and this consideration is also lawful. Last example. X agrees to sell drugs, opium, to Y, and Y agrees to pay 5,000 rupees per gram. What is the consideration for X? If he is giving drugs, what is he getting in return? Money. So for him, consideration is money. And what is the consideration for X? For Y? Drugs. There is consideration for both the parties, but is it lawful? No, this is unlawful consideration. Okay, this is unlawful consideration. Will this be a valid contract? No, not a valid contract. So consideration must be lawful. So there must be consideration for both the parties, and this consideration must be lawful. Section 23 covers lawful consideration and lawful object. Now, object is the purpose for entering into the contract. This purpose must be lawful. See, consideration and purpose, they go hand in hand. When the purpose is lawful, consideration is lawful. When the purpose is unlawful, consideration is unlawful. That is why both are discussed under same section, section 23. Here, object is lawful. Consideration is hence lawful. Object is lawful. That is why consideration is lawful. The object is unlawful. Consideration is also unlawful. So, object refers to the purpose for which the contract is entered. That purpose must be lawful. Agreement must not expressly be declared void. Now, what is the meaning of void? Void is the opposite of valid. There is a small chart which we will prepare, and then you can copy it later. Void. Now, void may be either void ab initio or just void. Void ab initio, it's a Latin phrase. It means void right from the beginning. Void means it is not enforceable by law. It's the opposite of valid. Void means it is not enforceable by, it's the opposite of valid. Void right from the beginning. X gave loan of 1 lakh rupees to a minor. Can you recover it from the minor? No, it's void right from the beginning. You can't enter into contract with minor. X agrees to give 5 lakh rupees to Y, and Y agrees to kill Z. It's void right from the beginning. You can't enter into killing contracts. Gambling, smuggling, drug dealing, these are all void right from the beginning. What is just void? Just void means the contract is valid when entered. But later on, due to certain circumstances, the contract cannot be enforced. It becomes void. Now, X promised to export onions to Y. X is in India, Y is in Bangladesh. When they entered into the contract, everything was valid. But later on, a war is declared. Okay, and the government imposed a ban on the export of onions. Now, when they had entered into contract, everything was valid. But because of this ban, now the contract cannot be enforced. It becomes void. A promised to marry B and they got engaged also. Just boyfriend promising to marry girlfriend, that is not a valid contract. They got engaged. Okay. A and B, they got engaged. This is a valid contract. It's a contract, huh? But unfortunately, before marriage, A died. Now the contract cannot be enforced. It becomes void. Now marriage cannot happen, no, it becomes void. So it becomes void later. Earlier it was a valid contract. But because of certain circumstances, now it cannot be enforced, it becomes void. So what is void ab initio? Void ab initio means it is void right from the beginning, and just void means it was valid when entered. Later on, it became void. So please note this in your notebook. Done. So your agreement should not be void, huh? And it should not be expressly declared void. Now in law there are certain agreements, like there is a small list. Again, we will discuss this in unit 3C. There is a small list. These are expressly void. Don't enter into these agreements. For example, agreements in restraint of marriage, in restraint of trade, in restraint of legal proceeding. These are all expressly void. Don't enter into such agreements. Meaning must be certain. Section 29. According to section 29, the agreements of which meaning is not certain, they are void. See, terms, the words, one word, one meaning. Double meaning words not allowed. Meanings must, the words, they must be certain and unambiguous. Unambiguous means clear. Ambiguous means confusing, unclear. Okay, confusing, unclear. Now, let's say that X is a dealer in different kinds of oil. Coconut oil, hair oil, sesame oil, mustard oil, etc. He agrees to sell 100 liters of oil at 100 rupees per liter. Is this a valid contract? And which oil is he selling? The kind of oil is not specified. Not a valid contract. Terms are uncertain. Sometimes the kind of oil is not given, sometimes price is not given. Not a valid contract. Acha, tell me if I make certain variation. X is a dealer in coconut oil only. Now he agrees to sell 100 liters of oil at 100 rupees per liter. Will this be a valid contract? Yeah, this will be a valid contract because it is understood that he's a dealer in coconut oil. So they're entering into contract for coconut oil only. Contract must be capable, possible of being performed. Now, X promising to sell rice to Y is a valid contract because it is capable of being performed. So this is valid contract. However, X tells Y, I will pay you 5 lakh rupees, and Y says, okay, I will bring a piece of moon from the sky. And aate I will also bring a star for you. This is okay in movies. It's not practical. It's not a valid contract. Foolish people are entering into such contracts. So showing dinosaur, showing treasure by magic, these are all impossible agreements, okay? Contract is void. Legal formalities. In case there are legal formalities, you need to follow them also. Like, I want compulsory that the agreement has to be registered, has to be stamped, it has to be attested, it has to be in writing. Alright, whatever legal formalities are required, we'll do that. Ma'am, if there is no legal formality, then you make the contract as per your choice. Even oral contracts are valid. But certain contracts, law requires them to be in writing. Like, for example, gift deed. X wants to gift his car. Now, law says if you want to gift something to the other person, like it's not a marriage, okay? If you want to gift flat, car, jewelry, so the agreement has to compulsorily be in writing. Otherwise, people will dispute. Like two brothers, they are fighting. No, dad left his house in my name. No, dad left jewelry in my name. If dad wants to give a gift, please put it in writing. It's the requirement of law. Also get it registered. If you want to sell an immovable property, the agreement has to be in writing. It's the requirement of law. You can't have oral agreement. And it also should be registered. Oral agreement is not valid only. So if there are legal formalities, complete those legal formalities. If there are no legal formality, then you make the contract as per your wish. All these essential elements must be present to make a valid contract. Even if one essential element is missing, it will not be a valid contract. They all have to be present to make a valid contract. So students, these were the essential elements of a contract, and I also hope that you understood the difference between agreement, contract, and you also understood the essential elements. We are going to discuss all these essential elements again in detail in the coming units. So from the next unit, we will start discussing the essential elements like offer, acceptance, consideration, lawful object, lawful capacity, everything we are going to discuss in detail. So this was just an introduction. And in case a question is asked on the essential elements, this is what you're supposed to write. In my next session, I'm expecting from you to write and practice these questions. Now, in case of a case-based question, okay, if you are asked a case-based question, you will divide your answer into 4 parts. Provisions, facts, analysis, and conclusion. Give the heading. Leave that line. Start writing from the next line. Okay? Now, what will you write in provisions? You will write the theory, section number, name of case law, if any. Sometimes students wish to prepare another tab for case law, like they will give the heading as reference case law. They will write the name, they will explain. So I leave it up to you. Write the theory, write the section number and name of case law. Leave a line. Then write facts of the case. You will just write the question very briefly in your own words. Write solution in analysis, and conclusion will start with hence, therefore, thus, so, it is therefore concluded. In 1 or 2 sentences, you need to conclude. See, the last part of the question is generally what you need to write in conclusion. You need to answer that. Will the son be able to recover the amount? So you will answer this in conclusion. You will also answer this in analysis. But in conclusion, you will again mention whether case can be filed. Try it out. In my discussion video, I have discussed the format, what to write in provisions, how to identify, how much is to be written. Everything is explained in detail in my next video. Here I am not explaining much because I want to see how you are writing the answer. Make mistakes, no problem. Be in doubt. You will get only 40%, 20% marks, no problem. But I don't want to guide you too much because first I want to see how you are writing. Then I will show you the correct method of writing so you will be able to compare. So attempt these 2 questions. Watch the next video where we have discussed the answers, answer writing format, how to decide what is to be written in provisions. So after you finish writing, you attempt this on your own, okay? Then watch the discussion video. So, okay. So take some time, revise, answer these questions, and I'll see you in the next session with the discussion of these questions.